Hello, Ethan Vessels, lawyer in Marietta, Ohio. I'm licensed both in Ohio and West Virginia. Today's question is, what do I do if my long-term disability insurance claim is denied? One of the first questions you should ask is, what type of long-term disability insurance do I have? And there's really two categories. Privately procured insurance, meaning you bought it yourself, or employer-sponsored insurance. If it is employer-sponsored insurance, that's usually governed by ERISA, the Employee Retirement Income Security Act, which I've discussed in another video, which carries additional requirements before you file a lawsuit. Once you've determined what type of category your claim fits into, whether privately procured or employer-sponsored, regardless of those two categories, you will still want to determine what type of definition of disability are you complaining of under your policy. Every long-term disability insurer has a different definition for disability, but they break down into general categories. One is what we call any occupation, meaning your long-term disability insurer will pay if you become hurt or sick and you're not able to perform the functions of any occupation. This is not as favorable to employees because if you are working at a job and you become sick or hurt and you can't do your job, but you can do any other job, you will be held to be not disabled by your insurer. The other category would be what we call your own occupation exclusions, or I should say definition of disability. What this means is if you are, let's say, a trapeze artist, and you become hurt or sick and you cannot work as a trapeze artist anymore, if you have your own occupation as the definition of disability, if you are not able to work as a trapeze artist, but you could do something else, your long-term disability insurer will still deem you to be disabled and pay your benefits. So there's a big difference between the two. One of the more common types of definitions that I have seen, which is a hybrid of your own occupation, would be the percentage of earnings. For instance, if you are unable to work at your own occupation and you are unable to earn 60 or 80% of your pre-disability earnings, whatever your plan may define as the percentage, then you will be deemed disabled by your long-term disability insurer. So your claim has been denied. You get a letter in the mail saying they will not pay the benefits. The first thing you should do is make sure you know how long you have to appeal the decision, because you will appeal the decision and you must make sure you have all the evidence that you need. Oftentimes it's 180 days or 6 months. On privately procured plans it might be different. Make sure you write the date down and don't miss it. Don't wait 5 months before you start doing something. You want to start now. Next, what do your doctors say about your disability? This is the most important thing. If you are claiming that you're sick or you're hurt and you're not able to work, whether it's your own occupation or any occupation, you need to know what your own doctor will say. If your own doctor says that you are able to work, and that's the opinion he'll give, you're not going to have much success with your long-term disability insurer. However, if you have your own doctor, particularly a specialist, whether it's an orthopedic surgeon or a neurologist, or whoever is treating you, and their opinion is that you cannot work, you need to get that opinion written down and sent back to your long-term disability insurer so they know that your doctors think you are disabled. Next, have you had a functional capacity evaluation? Separate and apart from your doctors, you may have gone or should go to a person, it's usually a physical therapist with special training, who will conduct a series of examinations and tests on you. Sometimes it takes hours and even a day or a day and a half to find out the things that you are physically able to do and physically not able to do. Whether you're able to sit, stand, walk upstairs, whatever it is, and then they will write up a report which further illuminates what you can and cannot do, and you can send that to your insurer as part of your appeal. Next, have you been awarded Social Security disability? If you've applied for Social Security disability and been deemed disabled and are now receiving Social Security benefits, This can go a long way with your long-term disability insurer. It's not case dispositive. They don't necessarily have to use that determination, but it certainly can help you. So you'll want to make sure that you have done that or in the process of doing that. The most important thing, which I've already alluded to about long-term disability claims, is don't wait. You receive the denial letter, start the next day trying to build your case. You make sure that you meet the deadline. I can't stress that enough. If you miss your deadline and you decide to sue, you will probably not have enough in what we call the administrative record in order to successfully win a lawsuit. That brings me to a final point. I recommend that you hire a lawyer if your long-term disability claim has been denied. Yes, there are people who have successfully appealed their own long-term disability insurance claim. You can try to do that yourself. However, my experience has been that most people, 90%, are not able to successfully appeal their own claim. I think you should hire a lawyer, particularly one who is experienced in long-term disability insurance claims and also experienced in ERISA if that's your type of claim, and you'll have a much better chance of success. If you have questions about your long-term disability insurance claim in Ohio or West Virginia, please do not hesitate to give me a call. My number is 740-374-5346, or visit us at our website, www.fieldsdehmlow.com. Thank you.